And the judge is bringing in the jury right now before he dismisses them for the lunch hour. But a lot to talk about. And this trial is unusual in the sense that you've got three defendants and they all have attorneys. And so they all want to talk. And that's why we've had the extensive argument just minutes ago. But I want to bring in our panel. First of all, investigative reporter Natisha Lance joins us today. Misty Maris, defense attorney. Darren Porcher, former NYPD lieutenant. And John Phillips, attorney, who is very knowledgeable in the citizen's arrest law, which some say is the heart of all of this. Thank you to all of the panel. But John Phillips, the other side of the story, there's always two sides to a story. And that's what a case is all about. That's what trial is all about, for the jury to determine as the trier of fact. The other side to this story is that there was a struggle for that gun. And that is what prompted the defendant to fear for his life, because in his state of mind as a reasonable person, if Ahmaud Arbery is walking toward to get my gun and use it on me, I have a right to self-defense. And we've got to listen closely to what the defense is saying in their opening statements, because they may have a different story. And here's the thing, John Phillips, when that shot goes off, that initial shot, I believe they're out of frame. You don't see it.
And I think that's the hardest part about this case, or where the most of the defense lies. And it's why she carefully circled areas on that last frame. And, you are going to have two sides. The difference is you're going to have the prosecutor's side, and then you're going to have, 1A, 1B, and 1C as each defense lawyer gets up there and tries to make this stand your ground or citizen's arrest or whatever their, best defense is to justify. But I thought the prosecutor was very effective, especially in the through and through, the gunshot testimony that's expected from the medical examiner.
All right, we're going to take a short break. We're going to come back. We want to let you all see and hear parts of the opening statement. It's very important. It is the evidence the prosecution says will come to this court to prove their case beyond a reasonable doubt. We'll be right back.
Really important. Did this guy break into a house today? Did he commit a burglary today? What did he do today that you have immediate knowledge of? That's just it. I don't know, says Greg McMichael.
John Phillips, the defense is using the citizen's arrest law as it stood at that time in 2020 to really form the basis of their defense. Now, the prosecutor is just saying that they never said that. They never said it to detectives, investigators in their statement. Tell everybody what the citizen's arrest law was at that time and how it was used.
And was at that time, because after this case, I've even met with Georgia congressmen. My office is a few blocks, or I have an office a few blocks from this courthouse, and they've since changed it because they realized it was a law in search of a problem. So, before this law was so Walmart and places like that could stop people that were stealing and shoplifting and say, okay, we're just going to detain you until law enforcement comes. Well, the problem is it was written so poorly that vigilante justice, people could read it. Kind of like people misread Stand Your Ground, George Zimmerman, Michael Dunn, and in those cases, people were able to misread the citizen's arrest and all of a sudden think that they can now have vigilante justice and their deputized badge to go, use force. And it was never meant to be that way.
So let me ask you, the law said reasonable and probable suspicion. Does that mean that the average citizen had to have probable cause of a reasonable person standing there involved in this believed that they could be killed or serious bodily injury with the citizen's arrest law? Or is it just that they know of reasonable and probable suspicion that a felony had been committed?
It should be the felony has been committed. And the law generally wanted, if you look at the case law, it wanted proof of that. That's the problem with subjectivity. That was the problem with Stand Your Ground. George Zimmerman was really wanted, if you look at the case law, it wanted proof of that. That's the problem with subjectivity. That was the problem with Stand Your Ground. George Zimmerman was told to stay in the car. Michael Dunn drove off after shooting Jordan Davis. you can't have the subjectivity here and say, and to your point, it's the most excellent way to put it. They didn't make that call to 911. They didn't say, look, we're going to do this. We're going to stop this guy because we think he's committed a felony. They just, they just kind of took the law into their own hands, and that's why they're charged for murder.
All right, and I'm sure we're going to hear that from the defense when they begin their opening statements about that citizen arrest law and how they're relying upon it for what they did that day. We're going to take a short break, and when we come back, you're going to hear more of the opening statements by the prosecution. And John Phillips, it is true. The defense is going to say burglary was the felony that these defendants believed had been committed, and the legal definition, according to the elements of the crime, trespassing onto the property of another with the intent to commit a felony, the commit to take something. They don't have to take anything, but we can't ask Ahmaud. He's not here. We don't know what his intent was. Maybe he dreamed of having a home like this and just went into that property looking around, just thinking about his goals for his life.
And I love the use of the term looky-loo, because it's so, just, oh, looky-loo. It just downplays everything. There's a lot of words she could have used there, but we all know what that is. We all kind of see the new house down the street. My house we lost in Irma, and we know people walked while we were rebuilding, walked through. It's just kind of part of it. And so, yeah, they have video. He clearly didn't take anything in the video. And it's why she's telling the whole story. A great lawyer named Keith Mitnick calls it embrace the horror. Tell the jury about the bad stuff in the beginning, and then you're gonna downplay it and just spread it all out, because the bigger story is this was murder.
All right, we're going to take a short break. We don't want you to miss a thing, because we are going to go back into the courtroom so you can see more and really look. The devil's in the details with some of these things the prosecutor is saying. Extremely important. We'll be right back.
To check his pulse? Yep. Or didn't roll him. I pulled his hand out when because he had his hand stuck up under his head. I pulled his arm out, and then I realized he didn't have anything in his hand, and saw that this ain't gonna last long.
So how will the prosecution use this video? There are questions about how the police handled the scene based on the body cam footage. I want to go to John Phillips first. We heard right now, and this is very close in time, right? So it's like an excited utterance from the defendant that he was struggling for the shotgun. Completely different from what we heard from the prosecution. Major issue in this case?
Well, again, it goes back to what does the video show? So if it wasn't for this video, you'd have 3 witness statements of people who were there versus dead Ahmaud Arbery. And, just watching the video of his mother reminds me of sitting next to Lucy McBath when she was undergoing Michael Dunn's trial. And Natisha was there when we were doing it, and it's one of the most emotional things. And she has to endure that video and will have to endure that video over and over again, because it is the inconsistencies from these body cams that's going to make the ultimate difference. If they had gotten together and had their story together, still might not matter as much, because you have this key video, and thank God for it, frankly.
John Phillips, what we do know is that, as I said, this happened very close in time, and that is something that courts have said lend to credibility, because people don't have the time to make something up. I want your thoughts on this body cam video, and what Brian is saying contradicts what the prosecutor said in opening statements.
It is. So everybody hears the word hearsay, hearsay, out of court statement. That's what this was. That goes to the proof of the matter asserted. But there certainly are exceptions. Excited utterance, things you say all excited, things you say close in time, things you say that are against you. This falls into those exceptions and the classic definitions. And to Darren's point, he's right on. We could hear them. We could hear the crosstalk. And, when the prosecutor went into kind of why there was a gap and the defense was really defensive about it, it's because this wasn't really treated like a homicide investigation. There was some camaraderie and some, oh yeah, I get it. Yeah. So the African-American guy, yeah. And so these statements really don't help, particularly when they have the video. And again, we didn't know about this video until that gap was over, and that's when it got turned over to GBI.
It's an excellent point, because in the civil complaint that the family of Ahmaud Arbery has filed against the officers, but the city and the county and so many people, they say that the three defendants were actually deputized by local law enforcement to be the eyes and the ears of law enforcement inside that subdivision if anything happened. To John Phillips, when you look at this opening statement by the defense, with all of the experience you have, what are your thoughts?
Oh, it was fascinating storytelling. And when you have a high-profile case like this, it's tough, because are you trying the case to the people in the box, or are you trying the case to the world? And the very ending kind of gave me that moment of chills, because he said, this is hard and unpopular to let his client off. And so he is recognizing the world, but very important, he's also recognizing the small community of Brunswick. There's a lot of First Amendment and racial them versus us language in his opening. Kind of us versus them, when seconds count. That all of this stuff you could hear the NRA say in ads. And they, that's a Brunswick area, Glenn County jury, is sensitive to that. It's a pretty conservative area. And then the final point that I'd make is who's the real victim? His dad had a stroke and he could be pulled out of the back, and his last possible thoughts were about his 3-year-old son. Very, very effective, as we knew it would be. There's two sides to every story, and they want to try to make this, oh no, we were trying not to be the victim, and it's Ahmaud that was the bad guy.